Okay, so we're a minute away from starting, and I know people are still filing in, but I just want to get through some of these announcements really quickly, and we can also put this information in the chat. Welcome, everybody. My name is Rachel Hasna, and I work for UMMS Division for Community Behavioral Health. This is our Law and Mental Health Didactic Series, and we're happy to have you. So in terms of the CEU process, we will submit a evaluation link in the chat. Copy and paste that eval link, fill it out, and then a certificate of completion is automatically generated for you. It is your responsibility to save a copy. So if you're on your laptop, you'll want to save that document to your computer. If you're on your smartphone, you'll want to take a screenshot of the document. We do not keep these for you, so please do that. If you're joining us by phone and you need access to the eval link, just send us an email and we'll email you the evaluation link. These evaluation links are active for about 48 hours, so please complete them within the allotted time frame. And I will be sending an email to everybody who is registered and or attended today's lecture with the link to the recording, the video recording, as well as the PowerPoint. So you will get that either end of this week or beginning of next week, and then I'll hand it over to Julie. Thanks so much.
Thanks, Rachel. Welcome everyone to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad to have you all here joining us today. My name is Julie Brovko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. First, I want to announce we are accepting applications for our Forensic Postdoctoral Fellowship. We have 2 spots available for the 2021-2022 year. Our brochure is ready to go. Email me if you'd like a copy. Next, I want to remind you to join us next week. At that time, Jason Dickinson is going to be presenting Putting the Strength and Limitations of Children's Testimony in Context. For questions that you may have today, please ask them in the Q&A section. We may ask or address some questions throughout the talk, but we will be saving most of them until the end. But just make sure you ask them anytime you feel comfortable. Finally, for those of you who are on a tight schedule but still need your CEUs, I will let you know when the hour has passed. We will likely be staying on longer to address questions, but to qualify for CEUs, you only need to stay for that hour. So now it's time for what we've all been waiting for. I'd like to introduce to you our speaker for today, Dr. Ira Packer. Dr. Packer is a professor of psychiatry at the University of Massachusetts Med School. He directs the UMMS Postdoctoral Fellowship Program in Forensic Psychology and directs the Forensic Evaluation Service at Worcester Recovery Center and Hospital. He also chairs the Designated Forensic Professional Committee, which is responsible for overseeing the training and credentialing of all psychologists and psychiatrists who provide public sector forensic evaluations for adults in the criminal justice system in Massachusetts. He has previously served as the Assistant Commissioner for Forensic Mental Health in Massachusetts and has served as the President of the American Board of Forensic Psychology. Dr. Packer received his BA in psychology from Columbia University and his PhD in psychology from the University of Pennsylvania. He has authored or co-authored over 50 articles and chapters, as well as 2 books, The Evaluation of Criminal Responsibility and Specialty Competencies in Forensic Psychology. Dr. Packer, on behalf of the University of New Mexico, the Department of Psychiatry and Behavioral Sciences, and New Mexico's Behavioral Health Services Division, I'd like to welcome and thank you for presenting today. We're so grateful for your time and expertise, and I'm now going to turn it over to you.
Great. Thank you very much, Julie, for that introduction. Glad to be here, although I guess philosophically, I'm not sure what here means in these times, but I will be talking about the Kahler v. Kansas case, but I do want to make it clear that, well, before I got to give these disclosures, right? I have no financial relationship, and the views expressed are mine and don't reflect on University of New Mexico or UMass Medical School. I do want to say that there were the 3 objectives that we put out here and describe the majority rationale, the minority dissent, but then also I put in bold, discuss the implications, because I think that's really what I want to focus on. And I do want to say that this is not going to be simply focused on the Kahler case. I will tell you that the most recent issue of APLS newsletter had a very interesting summary of the case by Christopher King and one of his students, and I apologize because I don't have it up in front of me, so I can't remember her name. But it's certainly, I would highly recommend looking at that, because that's, pretty good detailed discussion of the issue. What I really want to do is place this in the context of a much broader context of both the insanity defense in terms of the Supreme Court's view, including other cases that have built up to this, and then also really a discussion of what are the implications for the insanity defense. I will tell you, if I don't know, I don't think you have to answer these questions to get your CEs, but to be honest, there really aren't very many implications for forensic mental health evaluators in terms of current practice. Nothing in this case will change anything you do in terms of practice. However, I think that there really are lessons and takeaways in terms of how the law looks at the insanity defense, in terms of the role that we can all play, not just as forensic evaluators, but as psychologists, psychiatrists, academics, researchers, in helping the court understand what is there about the human mind, the brain, psychopathology, that may help address what is the best way of recognizing that there are a subset of people in society who are so impaired that they really cannot be held responsible for their behavior. So that really is the focus of what I want to be talking about today. So just going back a bit, because even though this is the latest case, this is not the first time that the Supreme Court was asked to address the issue of, is it constitutional to basically, for a state to abolish its insanity defense? Okay. Kahler is the first time that the Supreme Court has agreed to actually grant cert and accept the case. But it's interesting that it's the third time that this issue has come forward. So the first one was in 1994, State v. Cowan. And the Supreme Court didn't agree to accept that case. And it was brought on the grounds that the Montana statute basically said that evidence that the defendant suffered from a mental disease or disorder or developmental disability is admissible to prove that the defendant did or did not have a state of mind that is an element of the offense. This is also often referred to, and including in all the Supreme Court cases, as mens rea defense. Mens rea in the more narrow meaning of that term, and it's unfortunate, many of you probably are aware of this, but the term mens rea really is used for two different purposes. One is the more general concept of a guilty mind, but more narrowly, it's whether somebody was able to form the specific requisite mental state, and usually it's intent, in order to be found guilty of a particular crime. So this is the more narrow one, because it's, did you have an element of the offense, which is different than the broader insanity defense. And in this case, Mr. Cowan broke into a cabin, and I am purposely telling you a little bit about these cases, because one of the points I'd like to make is that I think it is really important to look at the specifics of these various cases and of other even hypothetical cases, in order to then come to some reasonable conclusion about, well, what would be a reasonable standard that helps capture the kind of cases that hopefully most of us would agree, somebody who should not be responsible versus somebody who should be considered criminally responsible. So Mr. Cowan broke into a cabin, he ate some food, he made himself at home. The victim, as a woman, came home, she realized someone had been there. It sounds a little bit like Goldilocks, and she calls 911, except that this is more serious because he breaks in, he assaults her. Good news is she survived. And he claimed when he came to court that he was under the delusion that the victim was a robot, not a human being. Both sides in the case, prosecution, defense, experts, agreed that Mr. Cowan suffered from schizophrenia, There was some difference of opinion on whether he was genuinely psychotic at that point in time. However, if the trier of fact had agreed that he was psychotic and genuinely delusional, the implication was that his ability to appreciate the wrongfulness of his conduct would have been severely impaired. However, Montana had abolished their insanity defense, so he could not use that as a defense. The only thing he could argue was that he did not intend to assault this woman, and he was not able to prevail on that. So they appealed to the Supreme Court, saying it's unconstitutional to use only mens rea and not have a formal insanity defense. And the Supreme Court said, we're not interested in even accepting this case. Quite a few years later, State v. Delling, this is Idaho. So Idaho is another one of the states that abolished their insanity defense. And this, unfortunately, should have been the best case for them to hear. It was the cleanest case if you think about what we know about the insanity defense and our current standards. So James Delling, who everybody agreed suffered from paranoid schizophrenia, became convinced that some of his friends were trying to destroy his brain. So acting on this delusion, he travels to Tucson, Arizona. This is in 2007, and he attempts to kill one of his friends, but doesn't succeed, okay? He then goes to Idaho and basically shot and killed two other friends. Now, he claimed that he acted in self-defense because they were trying to destroy his brain. The case was heard in front of a judge. The judge agreed he was mentally ill, acknowledged his schizophrenia, acknowledged his delusions, acknowledged that he did not appreciate the wrongfulness of his conduct. But since Idaho had abolished the insanity defense, he was not able to prevail because the only defense he could have had was very similar, was it says the mental condition is not a defense. However, you can bring in expert evidence of a state of mind, which is an element of the offense. And again, that's a mens rea, and he was found to have formed the intent, so he was found guilty. That case was appealed to the Supreme Court, and it would have been the perfect case for them to address, because you can't get any cleaner than that, is that if you accept that there's sort of a moral wrongfulness or even a legal wrongfulness, he would clearly qualify. So is it unconstitutional to eliminate that? But they didn't grant cert. Now, this case is not exactly on target, but it's so relevant and it shows up a lot in Kahler that I think it's really important to discuss this. And also, I think there are important lessons to be drawn from this case as well. So this is the Clark v. Arizona case. And Ira Clark was a young man who was diagnosed with schizophrenia. And again, both the prosecution and the defense experts agreed that that was his diagnosis. This is not one of those cases where there's some ambiguity about his diagnosis, okay? Basically, a police officer was called in the middle of the night. Somebody complained there was a pickup truck going round and around the block, blaring loud music. And the contention by the prosecution was that Eric Clark did this deliberately because he wanted to get the police officer to come. When the officer arrives, Eric Clark shoots him, unfortunately kills him, and then he runs away. So a gun was found nearby, stuffed in his cap. Now, the reason why this is significant, of course, is that that's going to be part of the argument by the prosecution. So this was one of those cases where there were both sides, both mental health experts agreed on, or all the mental health experts agreed on what his diagnosis was. However, there was disagreement about whether or not he was able to appreciate or know that his act was wrong. And Arizona had not abolished the insanity defense. They used what we sort of can think of as the second part of McNaughton, right? The second part is due to mental disease or defect, he did not know the criminal act was wrong. The only modification there is they had taken out the first prong, which is did not know the nature and quality of the act. So this is different than the first two cases we discussed, and it's going to be different than Kahler, in that in this case, the state, meaning Arizona, did include an insanity defense. They just had a sort of a truncated version of McNaughton. So in this case, what happened was his claim was, and his experts sort of backed him up, is that he had made statements prior to the shooting that he thought aliens were taking over Flagstaff, Arizona, where he lived, and some of them were impersonating government agents. There was evidence that he even put on, some bells on his clothesline so we could hear the aliens coming. Okay. On the other side, there was evidence that he had told people he wanted to kill a police officer, and there was some, difference of opinion as to whether that was because he was angry at the police or because he thought they really weren't police, but were aliens, and that's where there was a difference of opinion. Okay. On the other hand, there was also evidence that he ran away. He hid the gun, threw that away. That kind of suggests that maybe he did appreciate the wrongfulness of his conduct. In Arizona, first-degree murder is, even if it's not fully premeditated, if you kill an officer, a policeman or a legal enforcement officer, that constitutes first-degree murder. Okay, he claimed that he did not know that what he was doing was wrong. The judge disagreed with that, and he was found guilty. Okay, so his claim was, wait, I had a better shot at the first half of the McNaughton. In other words, I didn't know the nature and quality of the act. I thought I was killing an alien, not a police officer. And so that was the basis of that's one of the two bases of his appealing his conviction to the Supreme Court. The Supreme Court heard the case and they said, well, no, there is no minimum standard. First of all, we've never even said whether or not states have to have an insanity defense, but certainly there's no minimal standard. So just because they used half of the McNaughton case, meaning what they call the moral appreciation, and eliminated what they call the cognitive prong, that you don't know the nature and quality, that shouldn't make any difference in terms of legal standards, because there is no single standard that is considered constitutionally required. Okay. Now, this is sort of an aside, because I think, it's not something I want to focus on because it doesn't really relate to everything else we're going to talk about. But I think it was sort of interesting, at least, logically, that the court at least also acknowledged that, it doesn't make a difference anyway, right? Because basically, he's saying, well, they should have allowed me to argue that I didn't know that I was killing a police officer. I didn't know the nature and quality. But they said, look, if the judge really believed that, then the judge would have also believed that you didn't know that it was wrong, because you wouldn't know that it's wrong to kill an alien. It's different than killing a police officer. So they said, really, that first prong doesn't really add anything to the insanity defense, so it shouldn't matter at all. So that's sort of a secondary point. The bigger point for our purposes is that they said there is no minimal standard. We're not going to tell a state that you must include certain language, okay? The only other reason I point out this cognitive prong is when we get to Kahler, you're going to see Kahler is the exact flip of Clark, where in Kahler, he's going to be arguing quite the opposite, that, hey, the problem is you got rid of the appreciation or understanding the wrongfulness. So it's kind of the flip side of this one. Okay, so this is where we are now. We've gotten these, twice they denied cert. Once they accepted the case, but the case wasn't really right, directly on whether it's okay to abolish the insanity defense. But nonetheless, they made a statement that we're not saying there is any minimal standard that all states need to adhere to in order to have an insanity defense, okay? Now, he also had a second issue, and I think it's sort of worth mentioning here. The second issue was that he said, okay, if I don't prevail on the insanity defense, I should be able to prevail on mens rea, on forming the intent, okay? And what he argued was that he did not have an intent to kill a police officer because he thought the person was an alien, okay? And if this were accepted by the judge, it would negate the element of first-degree murder in Arizona. He would still be guilty, could still be guilty of either second degree manslaughter. I'm not sure of the details, but the point is that that could be used to negate first degree murder. Okay. The problem was that Arizona had case law, the case of Mott, which was a very odd case, by the way, just to be honest, because it allowed individuals to claim that they didn't form the intent, they didn't form mens rea, but they can only do that based on observational or lay testimony. They were not allowed to bring expert witness to address that issue. In other words, experts are limited to giving an opinion as to whether an individual met the insanity defense standards, but could not address whether or not the person had the intent or the mens rea. And basically, here's the cite for the case. It's limited only for its bearing on the insanity defense. Such evidence cannot be considered an element of mens rea. Now, that's sort of a very interesting sort of distinction that they're making. And fortunately, most other states, in fact, no other state that I know of has accepted this distinction. It doesn't make a whole lot of sense, to be perfectly honest, because the same kinds of issues that could be used to say, well, he thought it was killing an alien, not a police officer. If that's relevant to appreciation prong, why isn't that relevant to intentionality? But nonetheless, the court said it's up to Arizona, and if they want to funnel, I think that was the word they used, they want to funnel expert testimony into just the insanity defense, but not mens rea, then they have the right to do so. Okay, so that's sort of the background of where we are coming up to last year and then this year, because the case was heard in 2019 and decided in 2020. And now we have Kahler v. Kansas. Okay, so James Kahler was married. His wife, Karen, files for divorce, and she takes their 2 daughters and their son, moves out of the house. She's living with her grandmother, at which point James Kahler enters the house. He shoots his wife. He sees the son. He lets the son leave, does not do anything to him. He then goes around the house and shoots his daughter and his 2 daughters and the grandmother, and all 4 of them died. So this is a pretty intense case. And the next day he surrenders to the police. So Kansas had very similar language to what we've heard in Montana and Idaho, that mental disease or defect is, you can't use it for, there's no such thing as insanity, but you can use it to negate an element of the offense. His claim was, what he wanted to claim was that severe depression impaired his capacity to appreciate the wrongfulness of his actions, okay? But that doesn't count, because the only thing you can do is look at intent. And the language is right there. I'm gonna sort of read it again, but it's really only the culpable mental state. They don't have a formal insanity defense. So he now appeals to the Supreme Court on the grounds that this is unconstitutional for Kansas to so narrowly limit how mental state can be considered, to say you can only use it for intent. You can't use it to show that you didn't appreciate the wrongfulness of the conduct. So what happens in the Supreme Court? Well, first of all, I am going to just use a few, select quotes, because I think it says something about how these cases get decided. And one of them is just right there at the beginning or early on in the discussion. It says, this case arises from a terrible crime. So, if you're bringing a case in front of the Supreme Court and already the first thing they say is it arises from a terrible crime, you're in trouble, okay? But the reason I pointed out is, I think it's interesting they accepted this case and not Delling. Delling was very compelling. And again, all the caveats. I've never seen either one of these people. I don't know all the details about all the cases, but just reading what's available in these cases from the court cases, not just Supreme Court, but obviously there are lower court cases to start with, Delling was very compelling. And even the judge acknowledged that had this been a state that Idaho had a standard McNaughton insanity defense or an ALI, it definitely would have met those standards. Okay, the Kahler case, again, without giving a formal opinion, it doesn't seem very compelling, and he doesn't seem quite sympathetic. So you've got that problem right off the bat, is that the case that they're trying to use to raise about the constitutionality of an insanity defense is not one that's particularly compelling on the facts of the case itself. And here's a footnote from what the Supreme Court said. They said, we conclude only that Kansas's scheme does not abolish the insanity defense. So their language is very interesting. They're claiming, okay, that Kansas didn't really abolish the insanity defense, okay? And some of us might be scratching our heads, because I have to say, I thought they did, and most people think they did. And the amicus briefs really did seem to suggest that they had abolished the insanity defense, okay? But the Supreme Court had an interesting approach to this. They basically claimed that by leaving in the element of intent, that you could show that you didn't have mens rea, they said, well, that's the equivalent to not knowing the nature and quality of the act. So they basically looked at this, again, as like the flip side of the Clark case, where in the Clark case, you got rid of what they call the cognitive element. You didn't know the nature and quality, but kept the moral element. You didn't know that it was wrong. And they're saying, well, Kahler is just simply the flip side of that, is that they kept the first half, meaning, not know the nature and quality. They just got rid of the second half. And then it became an easy decision for them, because they said, we're just following our same precedent, which is, we're not saying there is any one specific language or standard that should be used for insanity or for acknowledging the role of mental illness in impacting somebody's behavior or criminal responsibility. We're just saying the states can choose how they want to frame it. And they looked at Kansas as basically saying, well, we really do still have an insanity defense. They might not call it that, but basically our insanity defense is the nature and quality of the act. I actually was somewhat surprised by that, because if you read through Clark, that doesn't really come across as if they were using that same reasoning in Clark. They seem to have come to the reasoning in this particular case. They also had a second issue, which I thought was very interesting. And they said, look, Kansas does allow you to introduce your mental state at the time of sentencing to lower your punishment. And not only that, you can even be sent to a psychiatric hospital in lieu of prison. So isn't that kind of like the insanity defense? And again, there are certain elements, of course, that all of us would probably say, yeah, that does sound in many ways similar, but there really is a big difference, because at the time of sentencing, you basically have to show that the person needs hospital level of care, okay? This case could have been years old, and by the time the case comes to trial, the person is more stabilized. So there really is an enormous difference between using mental state at this point in terms of sentencing versus saying, hey, how did that impact the actual culpability at the time that they committed the act? So, and that's just my editorializing, obviously. So as I said, they made it, the cognitive incapacity. Well, I actually did, sorry, I just want to go back to one other thing they said. They also concluded, they said, Kansas's scheme does not abolish the insanity defense. We say nothing one way or the other about whether any other scheme might do so. So they kind of hedged a bit. So though when you read some of these analyses, especially the legal analyses, which will say, well, Kahler v. Kansas, they didn't really say it's okay to abolish the insanity defense. They just said the case in front of us does not really abolish it, which is why, again, Delling would have been a much better case, because I think it would have been way harder to use this kind of reasoning. But they left open now as to whether or not some other state might have a scheme that they'll say, no, that's not good enough. But they didn't decide one way or the other. So that's still an open question, which I think is important to keep in mind. Okay. And then the next one. So this next footnote is, again, so and you'll see in a second where they got this from. Stephen Breyer, and wrote the dissent, and I'm going to talk a bit about his arguments because I think that they're very important. But they were looking at some of his arguments and trying to rebut them. But they gave this example. It says, Kansas believes that an intentional killer, again, intentional meaning I fully intended to kill another human being, is not wholly blameless, even if, for example, he thought his actions were commanded by God. Okay, so, okay, that really goes back pretty far. I mean, there are cases like in 1950, in the case of Schmidt, where the ruling was that if somebody really believed that God was commanding them to kill somebody, that would constitute insanity, okay? Because appreciation, even though you may know it's legally wrong, you think, you're compelled to do it because God is telling you to do it. Back in 1915, that was acknowledged as the basis for an insanity defense. They're basically saying, look, we recognize that Kansas has changed its scheme, its standard. And even in a case like this, they say you're not wholly blameless. You still are going to be found guilty. You may be able to use the mens rea for sentencing. Okay. And then they reflect on what Breyer says, because Breyer uses a very similar example. And they say the dissent, in contrast, considers Kansas's view benighted. Interesting term. But look at this in parentheses, as maybe some in the majority do too. So at least one or two people in the majority, I don't know who it was. I'm suspecting it was not Clarence Thomas or Alito, but what do I know? At least some of them thought, yeah, this is like ridiculous, benighted. I mean, that's like, it doesn't make any sense. But they said, look, we may not agree with that, but we're not saying that it is up to us, okay, to tell Kansas that they can't take such a benighted attitude because it's not unconstitutional. I think that's sort of a fascinating statement, by the way, that I'm going to want to come back to, because I think it really goes to the heart of, well, what are the implications of what could be done in the long term to try and develop some consensus standard about what really should be considered the basis for an insanity defense. Okay. And again, the way they got around this, they said, look, so we may not agree with it. And we also don't agree with the dissent's argument. I guess, the problem is I'm telling you what they're rebutting the dissent before I got to the dissent, but that's the order that, Supreme Court cases go, right? The majority goes before the dissent. This is not a dispute, as the dissent suggests, but whether morality should play a role, okay, in assigning legal responsibility. It is instead a disagreement about what morality entails. That is, when a defendant is morally culpable for an act like murder. So they're saying, well, we don't accept the dissent's argument that you have really not taken into consideration that some people may be so mentally ill as to not be morally responsible or legally responsible. You just get to set the bar at different places, and we think Kansas has the right to set the bar at the place that they did. This case reminds me a bit Montana v. Egelhoff, for people who know that case. That was a case where in Montana they said intoxication could not be used to negate intent. So that even if an element of the crime is that you form an intent, and somebody was so intoxicated or so drunk that they couldn't form the intent, although every other state will allow that to be used to negate intent, Montana said, no, we're not. And the Supreme Court in that case said the same thing. They said, well, we don't necessarily agree with that. We don't think that any other state needs to follow it, but you have the right to decide how you want to funnel this kind of information. And just like we can say intoxication cannot be used to negate insanity, if you want to say intoxication cannot be used to negate intent, intoxication cannot be used to negate intent, that's up to you as a state. So this is kind of very similar. They're giving just a lot of leeway to the states to decide how to apply some information or some knowledge or some thinking about various mental states. Okay, so let me get to the dissent. First of all, it was written by Justice Breyer and signed on by, there's only two other people because it was a 6-3 case, right? So he basically says, I think you're wrong in the way you've gone about this as a majority. You've basically just reframed this and said they haven't really abolished the insanity defense. They've simply redefined the insanity defense. And he said, it's just not true, right? He says, you have eliminated the core of a defense that has existed for centuries, that the defendant, due to mental illness, lacked the mental capacity necessary for his conduct to be considered morally blameworthy. Okay, so he's going way stronger, and he's basically saying that, oh, sorry, I didn't realize this is showing up on my screen here. I apologize. He said, you have gone way further than that. You basically have eliminated an essential element that has been in jurisprudence for centuries, both American and English jurisprudence, that due to mental illness, you can have such an impairment that you cannot be considered morally blameworthy for your action, and you've abolished this. And he then used two examples. He said, let's use, and this is what they were referring to in the majority when they said, well, you know, here are the cases you talked about. They said, look, we have two people. The first one is a psychotic individual who kills another human being under the delusion that the victim is a dog. In other words, he thinks he's shooting a dog, but he's really shooting a human being, okay? But he doesn't realize that. And the second case is somebody who's equally psychotic. This is an individual who is just as psychotic. He kills another person. His delusion is that some dog, which had some, I'm assuming, supernatural powers, ordered him to kill this person, and therefore he goes and does it. He says, look, these two people are equally psychotic, equally mentally ill, and really should be treated the same way by the legal system. They should both be considered at the same level of moral blameworthiness or not being morally blameworthy, okay? Under McNaughton, he says, look, any insanity standard in any of the 46 states that still have it, both cases would likely qualify as insane and could not be convicted. In both cases, you'd be able to argue, due to a severe mental illness, this person's ability to the cognitive understanding, their understanding of the moral wrongfulness of their actions could not, they didn't have it. However, on the Kansas law, he says only the first case would have a viable defense of not having formed the requisite mental state of killing a human being. Case number 2 would not have a viable defense because he did intend to kill a human being. He just thought he was justified in doing so, okay? So he used that as an example to say, look, let's use some very concrete examples to demonstrate why the logic that you and the majority are using just doesn't make sense, okay? And he then goes further by citing also from some of the amicus briefs. So there were there are probably more than two, the two wonderful amicus briefs, one by the American Psychiatric and one by a group of law professors, who both argued why the Kansas statute really was not constitutional. But what Breyer was really pointing to is he's saying the standard that Kansas used is out of touch with our current knowledge and understanding about mental conditions, about how mental illness impacts individuals. And he says mental illness typically does not deprive individuals of the ability to form intent. Rather, it affects their motivations for forming such intent. And this is really well established in a lot of the literature. Stephen Morse has written on the whole issue of intent. There was a wonderful article many years ago by late Charlie Clark, who described what the problems were in sort of looking at trying to claim that somebody didn't have the capacity to form intent. And the issue is, this is based on these amicus briefs saying this standard that Kansas has adopted is just out of keeping with our current knowledge, okay? Now, it's sort of interesting because the court, even in the majority, did acknowledge that the insanity defense has changed over the years in response to some more sophisticated understanding of human behavior. Okay. For example, they even mentioned that at some point the people thought that the standard McNaughton was not adequate. Some states added on the volitional prong. One jurisdiction tried the product test. Right now, that's limited only to New Hampshire, but at one point, as people probably know, was adopted in one federal circuit. But they acknowledge that, you know, there's evolution over time in our understanding of the psychology, psychiatry, the brain. There's an evolution of understanding of how various kinds of mental conditions can impact individuals' behaviors, and that changes over time. The dissent basically argued, yes, and it's changed enough at this point in time that the Kansas statute really should be unconstitutional. The majority actually used that same logic to say something different. They're saying, look, because it changes over time, we don't want to set in concrete any particular understanding or version, because once we set that as a standard, it will be harder to change over time. So they said, given the ambiguities, we think there shouldn't be a constitutional minimum standard set or standard that meets constitutional muster, but it should be developed over time, and each state can come to its own conclusion about what it wants to do. Okay, so I'm just going to go for a few more minutes. I want to leave time for questions, but I do want to talk about what I think are some of the takeaways, and then we'll be very happy to hear either comments about where you think are takeaways or any questions. So basically, you know, when you're looking at these two arguments from the majority and the dissent, you can see the courts are grappling with the limits of our expertise, okay? And any particular wording in any given state or any jurisdiction basically attempts to come to terms with what is the impact of mental illness on criminal behavior in light of some gray areas, okay? So what do I think we know pretty well? I think we have a pretty good basis for assessing how the impact of psychotic thinking on particularly delusional thinking can impact someone's understanding and appreciation of what they're doing. I think that's not an area that there is a lot of confusion about within the field of psychology and forensic psychology and psychiatry. However, the big issue is, at what point does that impairment go above a certain line? At what point does it become a substantial impairment versus a less substantial impairment? And that's where there's sort of still some room for discussion. But at least there we could say we have a good understanding of what the general issues are and how this affects individuals' thinking. Where, frankly, I think we sort of have a ways to go is I think we have less consistent expertise about what actually constitutes intent. At what point can we say somebody's acting intentionally or not intentionally? And I think we still have a very long way to go in terms of really being able to assess when somebody really is impaired in their volitional control. We know the extreme cases, right? I mean, somebody who's grossly manic, most of us would be able to say, yes, we think they don't have the ability to control their behavior. However, there's just a lot of room in other cases where there's just a lot of room to go back and forth. And it's really hard to argue that we could point to our science and say, now we know that this is somebody whose volition is that impaired. And you don't really have to look very far to sort of appreciate this if you look at the difference between the insanity defense and sex offender commitments. Somehow within the insanity defense, it's a much tougher standard to meet. And for when it comes time to saying, should a sex offender be treated as a sexually dangerous person, or whatever term is used in different states, it's pretty easy to establish that, well, they don't have the control over their sexual impulses yet. That doesn't qualify them for an insanity defense. And I'm not taking a position on this one way or the other. I'm just pointing out that there's an inherent contradiction and a limitation in our ability to say we have scientific knowledge of this. Okay, and I think in this context, it's worth looking at the this quote from a case back in 1994, Big V State. The issue of insanity is not strictly medical. It also invokes both legal and ethical considerations. They said ethical, I put moral, that's my term, because they don't mean ethical, they don't mean standards of ethics, profession, they mean moral. Otherwise, the issue of sanity would be decided in the hospitals and not the courtroom. So it's a fascinating statement. But it does get at the issue of, like, we have expertise we could offer to them, meaning the courts and the legal system. But at the end of the day, it's the legal system that's going to have to figure out how to apply that. Okay. So the question is, how can we help the courts fashion a standard? Okay. I actually think that Breyer was on the right track by using a prototypical analysis, meaning you use a couple of examples and see, can we all agree, and maybe not 100%, but is there pretty much consensus that these kind of cases, yes, this should count and this one shouldn't count? And we understand why these two are equivalent. And I think his great examples that he used of those two different individuals, even the majority, at least some of them, seem to think, yeah, you got a good point there, just that we don't want to carry it through to its logical legal conclusion. But that kind of approach could be very useful. And I'm just sort of going to end on this by saying, if people haven't read it, it's really worthwhile to go back to the ALI Model Penal Code, but not just the code, there's a whole annotated section. And there's fascinating discussion between attorney Herbert Wexler, who was, I think, the lead lawyer in developing at least the insanity defense, and a very well-known psychiatrist, Manfred Gutbacher, where they did look at prototypical examples. And the most compelling one that I saw was Gutbacher really wanted, on behalf of psychiatry, to say, you know, we like the product test. We don't want to get into appreciation, conformity. We're worried that that's beyond our expertise. Let us just say that we'll say whether or not this particular behavior was a product of mental illness. And Wexler came back and said, look, I got an example for you. Here's a man who delusionally believes that his uncle is a very wealthy person. It's not true. He also delusionally believes that if his uncle dies, he's going to leave all the money to him. So he goes out and kills his uncle in order to get the money. Wexler says to Gutbacher, well, that's clearly a product of his mental illness, right? Without his mental illness, he wouldn't have done that. But he said, this doesn't feel right. This person should not be considered morally blameless, because if it was true that his uncle had all that money and he killed him to get the money, we'd say, of course he has to go to prison. He's guilty. So why should he be able to say I'm not morally blameworthy simply because my belief about my uncle was not true, it was delusional? I think that approach is really the approach that I hope, I think would be helpful in moving this discussion forward. And I don't know what form that could take, but I think at some point it would be great if there were a rethinking of the whole model penal code for the insanity defense. I think it would involve forensic psychologists, forensic psychiatrists, lawyers, including academic lawyers, to try and think through using all these cases to say, what can we all agree that this kind of person should be in this bin, meaning morally blameworthy, and these not morally blameworthy, and then let's see if we can develop a standard that will capture them, most of the time, people in the right bin. Okay, so with that, I just left the some references, and obviously the three of them are the cases, but I did leave, I also put up the article by Christopher King and Morales, which was just in the recent issue of the APLS newsletter. So with that, I'm going to stop here and then take questions.
All right. First of all, thank you very much. That was fantastic. The first question that's come up is, was the constitutional issue in Kahler whether or not abolishing the insanity defense was a violation of equal protection under the law?
That was due process, I believe. I think it was a due process issue, not equal protection. But any lawyers here who know better can tell me that, but I'm pretty sure, I mean, I just read it, but that's what sticks in my mind. It was more of a due process concern.
Next question is, what about the requirement in SME courts, including in New Mexico, that the defense has to show a well-documented history of mental illness? This ignores the fact that a person may have acted very early in their illness, like their first break, or that they have not had access to treatment, so no history per se.
Well, first of all, what does SME mean?
I'm
Oh,
not.
you don't know either. Okay. Well, yeah, I mean, I agree. So, but I don't think that's relevant to this kind of discussion. That just is relevant to what kind of evidence would you need in the first place to establish that somebody has a mental illness. Now, of course, it's better if they have a long history, but there are people who, during their first break, are commit an act where they're not, where they are psychotic and maybe delusional and therefore don't appreciate wrongfulness. So it doesn't make any sense to me. I don't know how to answer that because I don't really know what kind of court that is and why there is such a standard.
They just clarified they meant some courts, but okay. The next question is, does the opinion in this case support a guilty but mentally ill as a form of the insanity defense?
Okay, so first of all, that's a kind of meaningless, the guilt but mentally ill is a meaningless concept. It doesn't really do anything. All it says is if you're mentally ill, but you don't qualify for the insanity defense, we'll call you mentally ill. Most states, that doesn't really buy you very much at all. I will tell you that I was in Michigan back in the, late 70s, early 80s, right? Early 80s. And Michigan was one of the first states to have the guilty but mentally ill. And there was an excellent article written by a couple of people from the law school arguing that the word but was absolutely misleading, that it had an implication that if you're guilty but mentally ill, somehow you get a better deal than if you're just plain guilty, okay? And as a result, it turned out that almost all of the cases in the early years were plea bargained. And they said, what did the person just plea bargain for? They acknowledged they were guilty. They got sentenced to the same sentence they would have gotten probably. And in fact, there's some data that came out much later that showed that people guilty of mentally ill, I think it was in Georgia, got bigger sentences or longer sentences than if they hadn't. The but doesn't really buy you anything. And again, maybe in the early days, in the early 80s, okay, so let's say there was some advantage to it, because this way, if you went to prison, the prison would have to acknowledge you're mentally ill and maybe give you some treatment. By now, there's well-established law that all prisons must provide mental health services to mentally ill individuals. So it doesn't buy you anything being called guilty but mentally ill. And so yes, if there was a state that had GBMI, these individuals, Delling and maybe even Kahler, would qualify perhaps, but it wouldn't change anything in terms of their culpability.
Considering what we know about brain behavior relationships, why was the volitional prong abolished, leaving only the cognitive prong?
So that was somebody who was obviously younger, because those of us who were around in 1983 know that the volitional prong was abolished because people thought that John Hinckley got away with it. Okay, that literally was what happened. People were very upset that John Hinckley was found not guilty by reason of insanity for shooting President Reagan and Press Secretary Brady. And they thought that the jury was swayed by the volitional prong more than the cognitive prong. So a lot of states went about getting rid of it. The American Bar Association, people should be aware, supported the abolition of the volitional prong. The American Psychiatric Association supported the abolition of the volitional prong. The American Psychological Association just didn't take a position one way or the other, but it was political. It really was not I don't think you could argue anything more than that. However, I think it is fair to say that most people who've been doing this work for a long time will say that we're on much shakier grounds on the volitional prong anyway than we are on the cognitive prong. But I wish I could say that the decision to do so was based on hard science. It was based on the politics of the time.
If the state where you practice has a very limited definition of insanity and the defendant you are evaluating was mentally ill at the time, but does not conform to your state's statute, would you ever provide a diminished capacity type opinion, even if your state does not allow for diminished capacity per se?
I don't know how to answer that. I mean, if it doesn't have one, what are you gonna, you can't testify to something that they won't let you testify. Nobody's going to allow you to get up in court and say, you know, I think this person has X, Y, and Z. They'll just say, you know, Your Honor, objection, that's not part of our standard. So no, but in addition, but here's where I think that question, there's like a lot of depth to that whole issue. Most people will tell you that the really diminished capacity doesn't make any sense. Stephen Morse wrote this great article years ago called Diminished Capacity, a Moral and Legal Conundrum. And he pointed out that really diminished capacity, we can't really say that somebody's capacity to form intent was impaired, okay? What we can say, or not, well, one can say, it's not clear that a mental health expert can say, is that somebody did not form the specific intent. So even take Mr. Clark. Let's imagine that we believed that he really thought he was shooting an alien, not a police officer. We can't say that he didn't have the capacity to intend to kill a police officer. You could say, no, but in his case, he did not have that particular intent because he intended something else. But how are we, as somebody outside of him, as no matter how much expertise we think we have, we can't say, well, that was exactly what he intended or not. What we can say is he certainly had the capacity to form the intent. He may not have formed it if he really genuinely believed it. And California, basically, due to a whole bunch of cases, but ending up in the Dan White case where he killed George Moscone and Harvey Milk, and he did prevail on a diminished capacity. At that point, California realized the problem with that standard, and they changed their standards. They no longer have what's called diminished capacity. They call it diminished actuality. You can argue that I didn't actually intend to do this, but you can't argue, well, I have some mental condition that prevents me from having the capacity to do that, which is a much higher bar to meet.
Okay. What about a non-psychotic individual who has been socialized into a group based on shared delusions? If such a person kills someone in the belief that he's protecting the country, should he be acquitted or his punishment mitigated due to collective insanity?
That's a great question. I don't know if there is such a term as collective insanity. I will tell you that that's an issue that comes up quite a bit in certain types of cases. What are the posse comitatus, one group? There are these groups of individuals. I'm not saying they're delusional, but they have odd beliefs and they don't believe, they won't recognize the government. They'll get up there on the stand and say, well, I'm not gonna, accept your authority to even judge me. And it's a shared belief system. You would have to demonstrate that this particular individual had a mental illness that went beyond accepting the group's beliefs. If it's just part of the group's beliefs, that's unlikely to ever prevail on an insanity defense. You'd have to say, well, granted, he has the same beliefs as other people in this group, but here's why, because of his mental illness, he wasn't able to sort of form a rational judgment about whether to accept that or not.
Morse's article on Clark versus Arizona posits that the Supreme Court got it wrong on multiple accounts, including that they created this strange tripartite evidentiary scheme regarding when mental health experts can testify regarding mens rea, and that they often conflated insanity and mens rea in their rationale. It seems that the Kahler decision is another example of the Supreme Court's misunderstanding of the nature of mental illness and the importance of an opinion other than diminished capacity or mens rea for the truly mentally ill. What do you think about this?
Yeah, I agree. That's exactly right. I do think that they have missed the point. I mean, my personal opinion, so now I can say, is I think Stephen Breyer got it right. I think he understands it better. By the way, I don't know if people know this, but Stephen Breyer's wife is a clinical psychologist. I have no idea if that had any impact. I don't know if she talked to him. I don't know if he learned stuff from her, but I think he understood it. I think if you read, I mean, I'm not a lawyer, so I'm going to say that lawyers might argue back and forth about which side there had made more legal sense. I'm going to say it's very clear that the dissent made more psychological sense. And I do think he has a better understanding of that whole concept of here is how mental illness can impact individuals' thinking and behavior. And I think the majority didn't really get it. Although, you know, again, that one quote where they said, well, we agree it might be benighted, makes me wonder if they didn't get it. And makes me wonder if they just say, well, it doesn't matter, we're not here to sort of impose our views on people. The other issue that, you know, people have taken issue with, at least the Kahler case, is they're saying the court seems to be giving too much weight and too much credibility to state legislatures to come up with a standard, and not realizing that, you know, they really, you can't really trust state legislatures to do this. I mean, to be honest, what are they going to do? They're going to react to the next big case. Somebody asked about the volitional prong. Well, that's how the volitional prong got eliminated, because people worried that too many people are getting away with it. Okay. Guilty but mentally ill in Michigan, by the way, was developed after a particularly heinous case where somebody did something really terrible, managed to prevail on the insanity defense, and they said, we don't want that to happen again. So let's make it more difficult to use the insanity defense.
Okay. Just to let you all know, it is 1 o'clock. If you need to hop off, make sure you fill out your CEU survey, take a screenshot, print it out. We don't send copies. We are going to answer questions for a few more minutes. So if you do have any burning questions, please get those into us. The next question is, Bigby, which you cited, also says that knowledge of wrongfulness is not contingent on the defendant's understanding of wrongfulness, but whether the defendant understands that the larger social community believes the conduct was wrong. Is that type of conflation, or is that some type of conflation of the cognitive and moral standards?
So actually, no, that actually goes to a very different issue that is sort of beyond this talk, but I'll mention it briefly. There is several cases that go to the concept of, when you talk about somebody's impaired in their ability to appreciate the wrongfulness, do you mean subjective or objective? And that's what they're getting at. Objective is, I might think that, I'm sorry, subjective is, in my worldview, it's okay for me to do this. You looked at me wrong, you know, I'm in prison and anybody looks at me wrong, I know something bad might happen. So I was justified in killing you because this is my code of conduct. That's a subjective sense of wrongfulness. Objective is, do you know that everyone else, do you think that, for example, if everyone else in society knew what I knew, you would agree that I did the right thing? So for example, I know it's wrong to blow up that building, but I know if I don't blow up that building, there are people in there who are going to come out and kill a lot of other people. So I've saved a lot of lives by blowing up this building. I know blowing up a building is objectively wrong, but and you should believe me. And if you believe what I believe, then you'll agree that what I did was morally justified. So that's what Bigby is really focused on. And there are a number of other cases just like that. One case is the Segna case, which is sort of worth looking at. That's one of the few cases where a court was willing to say, we're going to go by your subjective understanding. Most courts have gone the other way around and said, just because you believe it that's your subjective view of the world that doesn't count unless you're so impaired that you can't even understand that even other people, if they knew what you knew, wouldn't do the same thing.
All right. I think we're good for today.
Great.
Anyone else have questions? Nothing's come up. Dr. Packer, thank you so much. We really appreciate it. It was great to have you this week.
Great. It was a pleasure being here. Thank you all.
All right. Have a great week. We'll see you all next time. Dr. Packer, I will add you to our email list.
Thank you.
Okay. Bye.
Bye.
Thanks so much, Ephraim, for your help.
Yes, Fred, thank you so much.
We will send out the link to this video and the PowerPoint slides towards the end of this week or beginning of next week. So people can expect that. So I'm going to just end the meeting, Anthony, okay?
Okay, sounds good.
Okay, great. Thanks, everybody. Have a great day.
Thanks, everyone. Have a good rest of your day, folks.
Bye.